The Securities and Exchange Commission's Division of Examinations has released a new risk alert that should be on every investment advisor's radar. The alert focuses on ongoing, widespread problems with compliance under the SEC's marketing rule, particularly around testimonials, endorsements, and third-party ratings. Even though this rule has been in effect for several years, examiners are still finding significant gaps in how many firms are implementing it. The key message from the SEC is simple but important. Marketing rule compliance is no longer treated as a transitional or new rule issue. It is now embedded in the SEC's core examination program, right alongside other fundamental compliance obligations. And when examiners identify marketing deficiencies, those issues often impact more than just the marketing rule. They frequently connect to the compliance rule and the books and records rule as well, which means one problem can quickly become several. That's why this alert matters so much for firms that rely on client reviews, referral arrangements, social media influencers, or industry awards in their marketing. The marketing rule was intended to modernize outdated advertising restrictions and give advisors more flexibility in how they communicate with the public. It allows testimonials, endorsements, and third-party ratings, but only if firms meet specific, ongoing conditions. What the SEC is seeing in practice is that many advisors have moved quickly to adopt new marketing strategies, but more slowly to build the compliance systems needed to support them. In many exams, staff observed that firms treated marketing compliance as a disclosure exercise rather than a supervised compliance function. This has led to structural breakdowns, such as failing to recognize when a relationship counts as an endorsement, failing to document why the firm believed disclosures were made properly, or having written policies that exist on paper but are not actually followed. With testimonials and endorsements, examiners found repeated failures to provide clear and prominent disclosures at the time the statements were made. Common missing information included whether the person was a current client or investor, whether they were compensated, the material terms of that compensation, and any conflicts of interest created by the relationship. Importantly, the SEC emphasized that hyperlinks are not enough. Disclosures must appear alongside the testimonial itself and be at least as prominent as the promotional statement. Firms that embedded third-party reviews directly onto their websites often struggled to demonstrate compliance with this standard. Oversight failures were just as concerning. Many advisors lacked written agreements with paid promoters, misunderstood the de minimis compensation threshold, or failed to document a reasonable basis for believing that promoters complied with disclosure requirements. In some cases, advisors even compensated individuals who were not eligible to serve as promoters due to disciplinary history, without adequate vetting or monitoring. The alert also highlighted persistent weaknesses in how firms use third-party ratings, such as awards, rankings, or badges. While these are often displayed prominently on advisor websites, examiners found that many firms did not conduct or document the required due diligence on how those ratings were created. Advisors must have a reasonable basis for believing that surveys or questionnaires were structured to allow unbiased responses and were not designed to produce predetermined outcomes. Yet many firms did not review rating methodologies, relied solely on marketing materials from providers, or lacked internal procedures for evaluating ratings altogether. Disclosure failures were again widespread. Advisors frequently omitted key details, such as the date of the rating, the period it covered, the identity of the rating provider, or whether the firm paid for the rating, logo use, or enhanced placement. The SEC made clear that indirect payments, like paying for priority placement or licensing a logo, still trigger disclosure obligations. Footnotes, small print, or buried links at the bottom of a web page do not satisfy the clear and prominent standard. Overall, this risk alert reinforces that marketing rule compliance must be systemic, documented, and actively supervised. Advisors should be prepared to provide examiners with written marketing policies and procedures tailored to testimonials, endorsements, and ratings, along with promoter agreements, compensation records, and due diligence files for third-party ratings. Firms should also be able to demonstrate their reasonable basis for believing that promoters complied with disclosure requirements and show books and records reflecting ongoing oversight. This is especially important for advisors who rely on marketing vendors, referral networks, or social media influencers, where responsibilities can easily become blurred. The practical takeaway is that this alert should prompt an immediate self-assessment of your compliance with the SEC's marketing rule. Firms should inventory their marketing materials, reassess promoter relationships, and pressure test whether their disclosures, agreements, and oversight practices would hold up under SEC scrutiny. Proactive remediation now, before your next exam, can significantly reduce regulatory risk later. Need to stay current on regulatory updates and compliance trends? Subscribe, and check the link in the description to sign up for our free regulatory alerts at www.legaylaw.com. At LeGaye Law, we make regulations make sense. Thanks for watching.